Good morning, everyone. Thank you for being here. And welcome to Estate Planning Made Simple, choosing the right plan for your family. We're thrilled that you're here today to join us for this very important topic. Thank you for taking time out of your Saturdays to be here. Since you're here, we know the topic is very important to you and your families. And so we're glad you're here. And the one goal behind this presentation is simply to educate you. And then for you to take that education and turn it into action. So with that being said, I do know a lot of you in the room, but I don't know a lot of you in the room. My name's Ryan Adams, and I'm a certified financial planner with Financial and Insurance Services of Texas. And I help my father-in-law, Randy, down there with our clients, and we help our clients grow and protect their wealth. And we do that through several means regarding investments, insurance, retirement income planning, tax planning, and estate planning. But we can only do so much as estate planning advisors, if you will. That's why we brought along the Johnson firm. Richard and Marcie Johnson will introduce themselves in just a moment. But it was important that we bring the experts to you to help you guys make the plans that are important to you and your families. At this point in time, I'm going to let Randy introduce himself and maybe a little bit more about the firm. And then Randy will allow Richard and Marcie to introduce themselves.
My name is Randy Balch, and many of you know me already. Been in this business for 50 years plus. I won't say how long. Started out as an insurance agency, basically, and ended up working in financial planning and eventually into securities and money management. And we've been doing that now for the past 15, 16 years. And many of you are clients of ours already. I recognize you. I still have it up here, maybe. I found Richard I guess it was about 3 years ago. And Richard actually did our first will and living trust for my wife and I. And it needed to be updated. Our children were grown. And I called Richard, and I found him, actually. I thought I'd lost him, but I found him, and we got reacquainted. And he ended up doing some more work for us and helping us bring our estate up to speed, if you will. And so I love this guy. I love his daughter, Marcie. And I think that I know that when I call him, he's going to call me back. We sent several of our clients to him, and they tell us that he gave free pens and all kinds of stuff to them. He didn't give me anything when I was there, but anyway, the point is that I love working with this firm, and I see a great relationship going forward. And so this is one of the reasons why we wanted to have this seminar, is to kind of introduce you to the Johnson firm and to get reacquainted with us if you haven't been acquainted with us before. So I'm a certified wealth strategist, and Ryan is a certified financial planner. So together, with these credentials, we can do a pretty good job. And we really do enjoy working with clients and helping you keep what you've got and helping you take care of catastrophic situations. So with that, Richard, would you like to introduce yourself?
Sure. My name is Richard Johnson. I practice with my daughter, Marcie. We have an office in Richardson, and we specialize in estate planning, probate, and elder law. I'm board certified by the Texas Board of Legal Specialization in estate planning and probate law. Been doing that exclusively since, 1990 or so. I've been practicing law considerably longer than that, but we specialized in this area because it was a situation where we could actually help people. People came in smiling, and they actually left smiling, which was a different scenario than the general practice was. But we enjoy that. Our philosophy, we have a motto that our family helping your family, and so that's kind of the way we look at it. So what I've tried to do is try to make estate planning fairly simple for people to understand. Even people with large estates have told me Richard, you got to make it simple. And sometimes it can't be simple, but sometimes it can be understandable. And so that's the key. Understandable doesn't always mean simple, but some of you got this book I wrote, Texas Estate Planning Made Simple in Texas, and what we tried to do is make it understandable. And there's a lot more to estate planning that's in that book, but they'll give you an understanding, I think, of the basics. And so if you understand basics, you can go beyond that. But we're also, Marcie and I both are VA accredited by the Veterans Administration to help veterans get qualified for certain benefits. And so I think Marcie's going to talk a little bit more about that later. But that's kind of who we are. We've been practicing in the Richardson, in the North Dallas area for a number of years. And
That's not in Oklahoma, by the way. That's
no, not that part of Oklahoma. Marcie?
And my name is Marcie Johnson, and I'm like Richard said, he said everything that I was going to say, but I'm an estate planning attorney, and I'm Richard's daughter. I've been with the firm 18 years. And I guess to distinguish myself, my passion is helping seniors. And I really started focusing on helping seniors protect their assets if they ever need long-term care. And so seeing the ability to get them benefits that, one, they didn't know about or that they thought that they would never qualify for, it was just life-changing for them. And so I feel like that's my passion, my mission, is to help those types of clients. And those are my favorite types of clients to work with. So we'll talk a little bit about that in just a minute. But I'm just so glad you're here. We have such a great turnout, and I hope that y'all learn something, and feel free to ask questions, and we're here for you. And we've got 2 sets of families up here, and so
I was just going to say that.
Oh, we're stealing each other's thunder.
Not planned, but planned at the same time.
Yeah.
Randy and I are family, and so are the Johnsons. So this is pretty neat. Good observation. Well, good. So here's what we're going to do next. Since it's Saturday morning, I know you guys are all looking forward to a quiz. We're going to pop quiz this morning to get us going and break the ice a little bit. 3 easy questions. Just first person to say a number, is going to, I guess, is going to be how you answer. First question here. What would you say is the percentage of Americans that have a will?
15.
There's a 15. Low. 25. Still low.
3.
Way low. Higher.
I need real.
Higher. Excuse me. Sorry. Lower. One more answer.
45.
You're warmer. 32%, according to caring.com in 2023, 32% of Americans had a will. We've got work to do. Question number 2. What is the percentage of people who don't know where their parents store their estate documents? Bit on the high side.
75.
Still high. One more. Getting warmer. 52% of people don't know where their parents or their family's estate documents are. Ladies and gentlemen, if you have estate documents, tell your family where they are. And then question number 3. What is the percentage of those under age 35 that created a will due to the COVID pandemic? High.
75.
Still high.
Do I hear 20%?
Getting warmer. 32%, the same number of people who have a will for those under 35 that have created the will. So you can see here in just these few statistics, folks, that we all have work to do as a society when it comes to estate planning. And that's one of the reasons we're here, to help us raise those percentages, okay? So with that being said, we thought we'd have a panel format. It's and I think our meeting is quite timely. They've recently renovated this room, so I'm comfortable. You all look
We
comfortable.
painted this room.
And instead of just 1 or 2 of us sitting up here and just talking, we're going to kind of have a conversation. And all I did was create 8 questions, and we're going to kind of ask of each other, and that will lead you to, we hope, to ask questions that are specific to your situation. So please don't be shy. Ask those questions, but we do hope to make the the theme come alive with regarding to estate planning made simple. So with that being said, we're going to start kind of with a baseline. We're going to talk about what an estate plan is, what wills are, and kind of give everyone just a basic foundation, because we don't know where you guys are with respect to your knowledge around estate planning and the documents. So we're going to kind of get started and then advance just a little bit with regard to what we all need to do. So with that being said, I'm going to ask our esteemed attorneys, how would they define an estate plan?
I got a pretty good definition, I think, that I found that I think covers it pretty well. The definition I came up with is I want to take care of my assets while I'm still alive. I want to take care of me and my loved ones should either one of us become disabled or incapacitated. I want to give what I have to whom I want, when I want, at the least possible cost. I don't want to pay any legal fees or court costs or taxes that I don't have to pay. That's kind of a definition I found. Is that okay? Can anybody add anything to that? I think that kind of covers it. Main thing is I want to take care of things while I'm still alive, because people don't want to do an estate plan, because if they think they're doing an estate plan, it means they're going to die, right? I got news for you. It's probably going to happen anyway, right? So that's my definition.
That's really key, Richard. I'm glad you said that. We have to take care of these plans while we're alive. We have to. Incredibly important. We work with so many clients who believe they have a estate plan, and what they have is a will that's not signed. So we're here to help close that gap, to help you guys understand what an estate plan truly is and how you guys can go about obtaining one. So with that being said, Randy, would you ask the panel question number 2, please?
Number 2, if I have a will or a living trust, is it all I need?
Thoughts?
Do you all know the difference between a will and a trust? Anybody know?
Perfect question.
Okay. Well, some of you, hopefully all of you, got the book I wrote.
They will.
We have it in the back
It's in
corner.
the back.
Oh,
I don't
it's in
have
the
it.
back. It's in the back. Okay, it's in the back. But it's on our website, johnsonfirm.com. So you can download that for free, and it talks about it. But basically, there's 2 types of plans that you can have. One, we refer to it as the court-controlled plan, and then there's a family-controlled plan. Neither one's better than the other. So, you think, well, I want the family-controlled plan. Well, not necessarily, because one's not any better than the other. It's just which one meets your needs. The will is the court-controlled plan, and it's not necessarily bad. It's just what it is. So if you have a will, what you do is you fill out this document, and then when you die, you take that document and you file it with the court. And the court has some rules and regulations that you go by. You go down, fill out some forms, you go down and testify, and you go through this process. And that process is called probate. Okay? And the judge typically appoints an executor or administrator, and that person gathers assets, pays off all the debts that you have, and then distributes the assets to where it's supposed to go. That's a process. And that process can take a few months, and sometimes it can take a few years to go through that process, but it's done with typically court involvement. All right. So the alternative to that is what we call the family control plan, and that's what the primary tool is a revocable living trust. And if you don't know what that is, I've referred to it as this big bucket. If you're single or married, you take all your assets and you put them in this bucket. The bucket has a handle on it that you're holding, and you're operating out of it. Business is normal; nothing gets changed while you're operating out of it. But when you die, or when you become disabled or incapacitated, not able to hold that bucket, you hand it to somebody else. Might be a spouse, might be a child, might be somebody else, but you hand it to somebody else who can keep managing what's in that bucket for you. So what that does, it avoids you having to go through a guardianship process and getting the court involved if you became incapacitated. Because if you can't handle your own affairs, maybe a judge has to appoint a guardian for you. So that avoids that. When you die, this bucket is handed either to a spouse or to the beneficiaries, and the trust didn't die, you died. And so there is no probate with the trust if the assets are in the trust. The problem you have sometimes is people don't always put all their assets in the trust, and then you might have a probate after that. But if you have all your assets in the trust, it avoids the probate. And so the administration is similar to what you'd go through in the probate process. There's some rules and regulations. The regulations regarding a will is contained in the Texas Probate Code. That's a code of law that says how things are supposed to be handled. A trust is governed by the Texas Trust Code, and those are rules and regulations. And basically, they're similar, except that with the trust plan, you don't do everything under the supervision of a judge. You stay out of the courthouse. You do it privately. So that's basically the difference between a will and a trust. And so if you have a will, then is that all you need? Well, what if you become incapacitated? The problem with a will is you got to die before it works. Okay. Now you laugh, but it was week before last. We had a lady come into our office, and her friend had a will, and she had the will, the original will, and she wanted to probate that will because she was the executor of that will. She didn't have a death certificate, but she said, we'll get that. So I did some checking, and I found out this woman was still alive.
Wow. Wow.
So we had somebody trying to probate a will for somebody who wasn't dead yet. All right,
Wow.
well, that's a problem. That's not going to happen. So you actually have to die before this thing works. Okay, and so with the trust, you may say, well, all you need is a trust. Well, a trust is fine if you have the assets in the trust. Okay, but if you don't have the assets in the trust, then it's just another tool. So the plans have to be completed. Have to be, you have to do some things in addition to just those plans.
So we create, when someone comes to us for an estate plan, it's not one document, because one document's not going to solve your problems. You need, at least there's about 5 documents that everybody needs. It doesn't matter if you are, 18 and you have no money, or you are, a multimillionaire. There are these documents that everyone needs. And I think I'm accidentally.
Yeah, no, you're just fine. I've got one more poll of the audience, and then we can go into these very important documents.
I would like to ask a question,
Please,
if I
Randy,
may.
please.
So I have a living trust, and I have a will, and I have all these other ancillary documents. My question is, when I die, it's my understanding that the will I have, which is called a pour-over will, if I didn't get everything into my trust that should have been in the trust or our trust, then do I have to go to probate with that will?
If you left anything out of the trust, it depends on what kind of assets you had out of the trust.
Okay.
Some assets don't go through probate. They don't go through, they pass by what we call operation of law. A retirement account has a named beneficiary on it. When you die, it just goes. You don't have to put it in a trust. You don't have to go through probate. It just goes. A joint tenancy with right of survivorship. You have a bank account with 2 names on it. One dies, it automatically goes to the other. Doesn't go through probate. Life insurance has a beneficiary designation. Doesn't go through probate. So you got a lot of assets that you may have that may pass to your beneficiaries without going through probate. Now you have a bank account. You have some land that you left out of the trust. Yeah, we're going to go through probate. We're going to take that will, that pour-over will, and put it back into the trust where it belongs. We refer to that pour-over will as it's like the spare tire in your trunk. Okay,
That's if you have a spare tire.
Yeah.
Most cars now don't have spare tires.
Well, you should. Your car should have. I always ask, how many tires does your car have? Your car should have 5 tires. But you hope to heck you never use that spare tire. And so that will is the same thing. We hope that we never use that will. But if we ever need it, we've got it to put property back into the trust if we left anything out.
We have another question.
Question in the audience.
Can you touch on that? I don't know if you can, without getting too far out in the weeds, when you have a trust, how does it also protect you, like, as you're living against lawsuits, whatever, would cause one of those against you?
Good question. Good question. There's two types of trust. Well, there's probably more than two types. There's a lot of different types of trust. Basically, there's two types of trust. There's a revocable living trust, and then there's an irrevocable trust. The revocable living trust is what everybody here, it's a living trust. That's what you've heard about, it's a living trust. Has absolutely zero asset protection while you're alive, okay? Now, that's revocable. Now, when you die, typically, if it's set up right, that trust can become irrevocable to your beneficiaries, and it's asset protected for them, not you, okay? So there are some things that you can do while you're alive to get asset protection, but the living trust by itself typically is not asset protected. Now, certain assets are asset protected in Texas by law.
Yes.
If somebody sues you, you had a car wreck and somebody sues you, they can't get your retirement account. They can't get your homestead. They can't get your life insurance proceeds. Okay? They can't get your annuities. They can't get $60,000 of your stuff if you're married. Okay? So there's a lot of assets that they can't get that are in that living trust. Okay? But the living trust itself won't be asset protected.
Thank you.
I want to go back to what Randy said, but talk about the will outside of a trust situation. Because I have a conversation, talking to the ladies here, I want to say every couple of weeks I have a surviving spouse who comes in just to look at her documents, and she'll tell me that her husband passed away. And I say, well, who owns the house? And they'll say, well, I own the house. My husband's will said the house went to me. And I'll say, well, did you probate that will? No, the will says it goes to me. Well, you have to go through probate for that house. Just because the will says it goes somewhere doesn't mean it goes there. It doesn't go there until a judge gives his court of approval on that document, because it can say last will and testament, and just as Ryan said earlier, you can have a document that says last will and testament. That doesn't mean it's a last will and testament, because it wasn't signed right. It doesn't have the right language in it. And so a judge has to say, yes, this is your last will and testament. You didn't do one after this one that says something different. So you've got to make all these allegations and prove that, yes, this is my the decedent's last will. This is where the property goes. That the person you named as executor actually qualifies to be an executor. Because you can name anybody, but some people just can't qualify. If you've been convicted of a felony, I'm sorry, you may really want that person to be your executor, but they just, under law, will not be your executor. And so it's just, especially for spouses, surviving spouses, they see that, and even children, they say, well, the will says it goes to me. That's true, but in order for you to sell that house, you have to go through a court process, and you only have 4 years to do it since the date of death. And so just because you have a will, most of the time, if any property is going to pass, you have to go through this court process. So I just want to make sure that there are so many people out there that don't understand that. And I have to be the bearer of bad news and say, well, now we got to go through probate. And so
I'd like to add to that, if I may.
Mm-hmm.
I think I read it in your book, Richard. It said something about it doesn't really become a will until it's probated. It doesn't really become legal until it's probated. So you might have it all drafted and nice and pretty, but until death occurs and until it goes through that probate process, it's not really legal.
I have a client right now that did their own will because they're trying to save money, and it looks like a will, but the problem is that the testator signed it one day and the witnesses signed it another day.
Uh-oh.
And so it's not a will because there are requirements specific requirements of how you sign a will, and you have to have 2 witnesses present watching you sign the will. If you sign the will and then take it to their house and say, will you sign this? It's not a will. They have to watch you sign it, and then you have to watch them sign in your presence. So this guy gave me this will, and it looks like a will, but as we went through it, realized it's not a will because the dates are wrong.
This is just one of many, many, many examples that we see on why you guys would want to use a professional for that, just that one example. So thank you for that. So a quick knowledge check. Based on what you've just learned with regard to wills and trusts, and this is, it's okay whether or not you have I'm curious to know of a quick audience poll, who in the room has a will-based, court-controlled estate plan? And that's okay. Thank you guys for being honest. And Paula, I'm going to make a correction on yours. Thank you guys for answering. Here's the cool part about those folks that have a plan. Whether court or family, you have a plan. Very good. Who in here has a trust, which would therefore lend itself to maybe a family control plan? Show of hands. Who has a trust? Thank you, Paula. You got it. Got a couple of questions here.
I wanted to add, when she said that to the states on the dates, we actually...
Hold on 1 second for the microphone.
Oh.
Oh, I want to hear what you have to
please do.
say.
Okay, what I wanted to add, when you said about the states on the dates, we actually used an attorney and paid an attorney, and when we got the final thing, she had made mistakes.
Oh,
on the
goodness.
dates. And so, I mean, we were having to, it was just ridiculous, I mean, for the amount we paid.
Oh, wow.
Yeah.
So you really do have to, even if you use an attorney, we learned the hard way, you still have to go through that thing carefully. So,
Right. Well,
Yeah.
thank you for sharing. Well, we make mistakes too, hopefully not very often, but
Well, a hard lesson to take is that if you've got a situation where you've got a mixed marriage, where you've got children from a prior marriage, husband's got children from a prior marriage, and he dies, and wife just doesn't get around to probating that will. You only have 4 years to probate that will, and so if you don't probate it in those 4 years, guess what happens? The state of Texas has a will for you. Okay. You probably aren't going to like this will, because what that's going to say is that wife owns her 1/2 of that house as her community property, and his children own the other half. Good luck trying to sell that house and only getting half of what you paid for it, but that's where it went. His half went to his children because of Texas law. So that's why it's so important not to delay and say, well, I'll get around to it. You got to take care of things when time comes.
So what you're saying for estate planning is, while it's important for everyone, especially for blended families.
Especially. Sometimes husband's going to say, no, honey, I'm going to leave everything to you, but you will take care of my kids when I die, won't you? Yeah. And she said, of course I'll do that. Don't worry about it. He dies, and she says, I never did like those kids. I'm going to leave it to my kids, all right? So there's ways to prevent that from happening.
Any questions before we move on to question
there's
number
one right there.
3?
What
Yes.
are the big myths about I think you're kind of touching on it, the big myths about wills and estate planning that we need to stay away from,
One of the big
or
myths
be cognizant of?
Good question, Amy.
is that it's not one and done. You do this plan. Most people do a will right when their kids are born, and then they change it again 19 years later when they go to college. But life happens, laws change pretty regularly, and your circumstances can change. So these documents need to be looked at. You can't say, well, I've got a power. I see powers of attorney from 2000. That document is probably not going to work today. That's 24 years old. So just because you have documents doesn't mean that they're going to work as efficiently as you want them to. So it's like getting an oil change in your car. You got to have it checked out every once in a while.
Yeah, one of our ongoing processes with our clients is an estate plan checkup. For every client we work with, whether they came in for insurance, investments, or tax, we're asking them about their estate plan and when is the last time that when it's been updated. And once we determine collectively, as advisor-client, we refer them on to the Johnson firm for those updates. And so, great question.
Well, do you have the same assets you had 10 years ago? Think back 10 years ago, do you have those same assets?
I have less.
Who's your planner? If you did planning 10 years ago, you planned for those assets, but now you got different assets. So do you need to look at this maybe a little differently? Has there been any marriages in your family in the last 10 years? Has there been any deaths in the family in the last 10 years? You have situations, have the laws changed at all in the last 10 years?
Oh, absolutely.
That federal estate taxes exemptions been going up and down like a yo-yo, and it's going to come back down again in 2026. Okay, so that changes constantly. So that's why you need to look at these things pretty regularly.
Question? Gabe?
My 2 seconds of fame.
Awesome.
So when you get either a will or a trust, is that filed anywhere legally in the court system?
The will is filed
A will
when
is-
you die.
When you die.
When you die,
Oh, okay.
so not filed until you die. The
Okay,
trust
so it
is,
just stays like, I mean, does your attorney keep, I mean, because sometimes, like you said, parents don't tell you where things are. So if you can't find it, is it filed somewhere that you can find it?
it's not filed anywhere. We keep a copy of the signature
well,
pages of the will.
I mean, okay.
We've actually had to probate copies of wills before, but we've had signatures which we could actually do that. So in the right circumstances, you can probate a copy sometimes. Depends on the court. But trusts are generally not filed. That's private.
I see.
And so nobody knows what you've got. They don't know the assets that you've got. They don't know what you did with your assets. They don't know anything about your plan because it's private. And only the beneficiaries are entitled to the information about that plan. The public is not entitled to the information, so they can't go check you out and find out what you had.
So what we do in our firm, like Ryan, I'm going to pony off of what Ryan just said. When we have our interviews with our clients, we ask them about these estate documents, power of attorneys, and et cetera, and we like to get a copy, scan a copy of those, and keep them in our file. So when a loved one does pass, at least someone knows, because they've talked to their family and says, hey, call Randy and Ryan. They have copies of those. Now that's just the copy, because we scanned it. And you'll have to tell them, or you can tell us, and we'll tell them where the legal documents are. But a lot of folks keep them in a safety deposit box, or they might have a safe in the home, and that's where they keep them. They should be protected. They should not be in a chest or drawer or in a kitchen cabinet, because you could have a fire, you could have some sort of a catastrophic event, and they would burn up. So you don't want that happening. But they need to be kept in a safe place. And you'd be surprised at the clients that take us up on that, say, yes, I'm bringing you those documents. Please scan them into our file, and then we have a record of it. I love what the Johnson firm does is they give you a notebook, and they also give you a little drive, USB drive, that has all these documents on them. So I can grab that, and I can take that with me wherever I go, and I've got a copy of my will and my trust and my power of attorney and all those kinds of things. Very, very important for those of us who are elderly. I don't see anyone in the room that's elderly.
Neither do I.
Except me. That whenever you have a catastrophic event, medical event, we'll talk about that later, but the hospital is going to want to know that you have a medical power of attorney. Because I want Paula to be able to make decisions for me if I can't make decisions for myself. And if we're in a car accident or whatever, then that could be a real problem. Because I couldn't say, yeah, doc, fix me. So
That's a wonderful segue.
Yeah.
So what I'm hearing Randy say is three locations for document storage. A copy in your home or a safety deposit box, potentially a copy on a flash drive or some type of storage medium that not only you but your family members know where these are. And then potentially with a family member or a trusted advisor, electronically stored. So if you have these estate documents, be sure you're saving them in at least 3 different locations and make sure your family is aware.
Can I say one thing there?
Please.
If you have a safe deposit box, make sure someone else's name is on the access, or that there's a key out there that someone can access, because if no one can get access to the will that's in the safe deposit box, I've got to go to court to get a court order to open that safe deposit
good
box.
point.
So just as a reminder, check whose names are authorized on that box.
One thing to consider about who you give that plan to, be careful. If you have a trust, you're going to name some backup trustees who are going to take over in case you can't manage things. You've got some names named in that document. Be careful about giving the document to those people, because if you ever change your mind about removing that trustee and want somebody else, you got to get the document back from that person, and they're going to want to know, why do you want the document back? So be careful, but you might want to tell them where it is, but you don't necessarily want to give them the copy. If that's the person, who's going to be in charge, you might change your mind about that.
Yeah, we'll be talking, a good point. We'll be talking about trustees and executors in just a moment, but I want to kind of go where Randy started to go with regard to the ancillary documents that make up an estate plan. So to this point, we've been talking about wills and trusts, but we're going to talk about the other documents that are relevant to an estate plan, a proper estate plan, and those are power of attorneys for both financial and medical, directive to physicians, declarations of guardians, and HIPAA authorizations. So Marcie, if you wouldn't mind, take just a few moments to go through and maybe define each of those ancillary documents that make up an estate plan.
Sure. Let's start with the power of attorney. There's 2 types of powers of attorney in Texas. We have a financial power of attorney and a healthcare power of attorney. And as I said earlier, both of those documents have changed by the Texas legislature in 2018. So if you have that document and it's prior to 2018, you might want to have it looked at. And the reason why is because it used to be you could have this document and any financial institution could look at it and say, I don't like the date on this document, go get me a newer one. We had one financial institution that it was 3 months after they had signed the power of attorney and they wanted a new one, which is ridiculous. So there was just, across the board, institutions were having different rules of when a power of attorney was accepted and when they thought it was stale. And so in 2018, they took away that ruling. So now if a power of attorney is done after 2018, it cannot be rejected because of its age. So that's the main reason why I would update that. But there's a lot of, so with this power of attorney, you're saying, a lot of people call it a durable power of attorney. So you can make it effective now. You don't have to wait till you're incapacitated. And that's helpful, and that's what we recommend, because you may not be incapacitated, you just may be out of town. Or you may be watching the Super Bowl and you need something taken care of and you don't want to miss the game. So you're letting someone else act on your behalf. And so anything financial, so banking, they can represent you in court, they can do estate planning documents for you, just anything to step into your shoes financially. And so the financial power of attorney is really robust now and allows you to do a lot of things. And so that's why it's so important to have that document. Especially, I'm going to put a plug in for my elder law planning. If we're trying to position a family to get on Medicaid or VA benefits, there are asset limits on what you can have. Well, so if we have more than allowed by the rules, we may need to do some gifting, move some assets around. And the power of attorney needs as much flexibility as possible so that we have the authority to do those things. So that's a financial power of attorney. Then you have a healthcare power of attorney. You can make medical decisions all day long as you're able, but if you can't, you need a legal document that says who can make decisions for you. And again, depending on where you are, what hospital, spouses say, oh, I'm the spouse, I can do it. Well, not always. It's not a given that just because you're married to this person that you're able to make decisions for them, that they will. So it's always important to have that document in place. That goes into HIPAA. So HIPAA authorization, you've all dealt with HIPAA, whether you knew it or not, because every time you go to the doctor, you say, these are the people who can get medical information about me. And so, but the problem is if you ever went to a different hospital, a different doctor on a stretcher, you couldn't fill out those forms. So then no one can get information about you. So we do a HIPAA authorization in advance that says, these are the people who can get information about me. They're not in any order, it's just a list. That way, if for some reason you do we don't know why you're going to the hospital, but if you go unconscious and can't fill out forms, your kids can run to your house or wherever you keep this document and fax it to the doctor and talk to them and find out what's going on. We had a lady that took her husband to Baylor Hospital, the emergency room, and she dropped her husband off. He went immediately in, and they took him immediately back to a hospital room. And she came in after she had parked the car and asked where her husband was, and they said, we can't even tell you if he's here.
Oh, wow.
And so she, being the headstrong woman that she was, just busted through the doors and went and found them. However, but that's a real life scenario. Also with children, we had one of our secretaries had a 18-year-old who played soccer in high school. She got hurt on the field, was taken to the hospital. She went to meet her at the hospital, and the doctor wouldn't tell her anything because that child is now an adult because she's 18. And so these are just documents you don't ever think you're going to need, but when you don't have them, you realize how necessary they are.
That's some of your children. If you got any college-age children off to school, they need those documents because if they're over 18, they're an adult. And you don't have automatic authority to find out what's going on. So they need HIPAA authorizations. They need powers of attorney as well. So, I mean, we do a college plan for people that want to do that, but it's just some bare documents for the college kids. But that's something that people don't think about. And
Okay.
I have a big boy side.
Wow.
So what about some of us little stragglers who have nobody, at least close by? And my medical power of attorney is in California. But if I have a heart attack and they drag me out the door and how do they know what's what unless I carry it in my purse? Is that what I should do? File it with every hospital in the area because you don't know where you're going to go if you're, say, in a car wreck or something. How do you protect yourself so that they're not pumping all this stuff into you when you want to say, hey, it's my time, leave me alone?
two places you can keep it. This sounds ridiculous, but it's true. We've had people put it in a plastic bag and put it in their freezer. I'm serious.
That's another place.
I'm serious because if there's a fire, it's probably not going to burn it up. And the EMS people know to look in the freezer. They know that. Okay, they know that. Another place you can put it is put it in your glove box. Okay. Now, if you put it in your glove box, the HIPAA documents that we have actually have your Social Security number on the document. So if you put it in your glove box, please mark out the Social Security number because if they steal your car, they got a bonus. They got the car and your Social Security number. So, but that's a good place to put it because if you have an accident, you're out of it. Somebody can look at the glove box. They got the HIPAA authorization. They know who to call.
Just a copy, or
Yeah, you copy. Yeah, you just copy.
Okay, I've got mine taped to my front door.
Yeah.
Well, maybe.
But I didn't think about fire, but
Well, you could tell, give it to your doctor and let them have it on file.
I have some.
And then, but to go back to your question, I have a lot of people that say, well, I don't have anyone local. Well, I would, with today's age, I've got clients with, their daughter lives in California, they're named. They can get in touch through fax, Zoom, what have you. So having them listed is better than not having anybody, for sure.
Don't put your cash in the refrigerator.
Put a note on that refrigerator documents inside if you do that, so that they will know. But a lot of times they will check that. But you might want to put a note on the refrigerator door, so documents inside. That's a safe place to put them.
The last document that I haven't mentioned yet is called a Declaration of Guardian. And that document is a catch-all. We don't plan on using that. We only use that document if, for whatever reason, they don't accept, when I say they, whoever, the financial institutions or doctors, they don't accept your powers of attorney. For whatever reason, they don't like them. And so a Declaration of Guardian says, okay, well, if you're not going to accept my powers of attorney, then these are the people I want to be my guardian to handle my finances and my person. Usually they're the same people. I had a call last week of a woman who said she needed to go through guardianship. My mom has got dementia, I need to go through guardianship. And I said, well, do you have a power of attorney? And she said, well, yes. Well, just know that a guardianship is the absolute last resort. Judges won't even allow you to go through guardianship if there is a less restrictive means to do so. So if you have a power of attorney, that's what you need, and that's what you're going to use. Guardianship is an extremely expensive process, and you're taking away the rights of they're called the ward, is their name. So the judges don't want to allow a guardianship if we could do something else. So that's why, if you have powers of attorney, that's what you're going to use. You're not going to go through guardianship unless for some reason they won't accept them. But so that's a catch-all document. So those are like 5 documents. You need a financial power of attorney, a healthcare power of attorney. We didn't talk about a living will. Well, that's directed to physicians, excuse me. Directed to physicians, I didn't talk about that one. That one says that if no one will make a medical decision for me, and I'm dying anyway, doctor says so. Don't keep me on life support forever. Just go ahead and let me go peacefully. No extreme measures. So that's a living will. So financial power of attorney, healthcare power of attorney, living will, HIPAA authorization, and a declaration of guardian. And that will cover you. Those are the 5, earlier I said the 5 core documents. So those are them. And then plus a will or a trust.
Going back to that Declaration of Guardian, some people don't want a person to be a guardian ever. Okay, so we had this couple that did a living trust. Husband and wife did a living trust. All their assets were in the living trust. He dies. She's got Alzheimer's. So we go to court, and the judge says, you got your assets covered under this living trust. That's fine, but you need a guardian for the person who's going to be the personal guardian. But she had 6 children, and she didn't want any of them serving as guardian. So luckily, we had a document. So I give it to the judge, and all 6 of them show up in court. And they all said, I want to be guardian, I want to be guardian. I handed the document to the judge, and the judge says, okay, none of you get to be guardian because she's disqualified all of you, and her good friend who was a doctor got to be the guardian. And so you can designate who can be the guardian and who can't be guardian. So some people care, some people don't care. But if you do care, that's a way to eliminate the wrong person from stepping up and getting control of you.
Well, that's one of the things I like about the living trust is you have an appointed trustee. If that trustee is unable to serve because of health reasons, then you have an alternate. And I would recommend several alternates so that they can continue to manage the assets of that trust as designed.
So if your spouse and you do not have documentation otherwise, would they be able to serve as power of attorney or as the person to go to for the DNR, assuming that you trust your spouse?
Yes. The answer is yes.
Some people don't.
If you don't trust them, then we got to go somewhere else.
There's other lawyers for that.
Great question.
Oh, look at there.
Can you address the paper, 2 pieces of paper that I've had to encounter with my mother who has Alzheimer's, the out-of-hospital DNR and the in-hospital DNR?
Well, the doctor can do the doctor can sign both of those. Okay, You can have a DNR that says, I don't want to be resuscitated, and you keep that out of the hospital DNR, and they won't resuscitate. But typically, a doctor's going to have to do the in-hospital DNR. You're going to have them okay that.
Well, I found out recently that what I thought was a perfectly good out-of-hospital DNR was not valid.
Really?
Yes, and I had to get a new one done for my mom. So you need to be very careful because the form, you can download it yourself and supposedly do it yourself. You better check with somebody because I found out the one I'd been carrying around for 7 years was no good.
Wow.
So it's something I advise people really look into very carefully.
I was in Leadership Richardson, so I know that the Richardson city limits, the fire department did a presentation. And they don't recognize directed to physicians if they come into your house. So they only recognize an out-of-hospital DNR. So if you have, and I don't know what Mesquite's rules on that or Garland, but I was very surprised. They will not acknowledge a living will or directed to physicians, only an out-of-hospital DNR. So if that's very important to you, you might want to get those documents. We don't provide them because the doctor has to sign off on them, but you can get the in-hospital and out-of-hospital DNR from your physician.
Just for the sake of the audience, can we define what a DNR is?
Do not resuscitate.
And that is different from a living will and a directive to physician. These are different documents, or can they be one and the same?
A living will is a directive to physicians that says, I'm dying anyway.
Okay.
The doctor has determined I'm not going to make it.
Okay.
The people that are listed on that medical power of attorney that we talked about, we can't find them.
Okay.
We can't find them anywhere. No, there's nobody to step up and say, this is what we're going to do because I have authority. Nobody says that.
Okay.
What do I do? And this document says, doctor, if that's the case, let me go. Keep me as comfortable as you can. Let me die as gently as possible. That's what that says.
Okay.
The problem with the DNR, if you're elderly, if they do resuscitation, they're going to come in there and they're going to pound that chest, and ribs are going to break, and bones are going to break, and it's going to make it a lot worse a lot of times than if you just let them go.
Okay.
So, and the odds of bringing them back, maybe you got to look at the quality of life, what they're going to have. So those are considerations to take if you elect not to have that done. But that's, some people say, don't put me through that. That's why they do it.
Thank you for clarifying. John?
So regarding DNRs, I learned about DNR. My father passed away. He had esophageal cancer. He was at home. They had done a DNR. Both him and my mom had done a DNR, and he, started having difficulty at home, was unconscious. My mom called 911. The paramedics showed up. They found him. They asked my mom if he had a DNR. She said yes. They said, do you have it with you? She said yes. They pulled it out. The EMT guys looked at it. I don't know if they signed it, but they gave it back to her, and he passed away at home. Interestingly, about a week later, my cousin, who's also a fire department, or fireman, we went to the firehouse to get some ice for something. We were doing a thing, and my cousin's like, let's go to the firehouse. We actually spoke to the EMT who came to the house.
Wow.
Oh, wow.
And my cousin and him spoke about the DNR, and they both said it was really great that he had it, that my mom had it, because had they not, in that county, they would have had to resuscitate. They would not have had a choice. So, I just think about my mom and my dad's down, and they're doing something she knows doesn't want to be done, and I was just so thankful that they had that document. It was there. She knew where it was, and the paramedics said it was easier on them because they don't want to do it either. I mean, if they say, do you have one, and they say no, they're legally bound to try to save that person, no matter whether they crush ribs and things. It's like, and he said it just makes it so much easier on them when you have that document, because it takes them off the hook, both legally and just ethically.
Yeah.
Because he said the worst thing to do is be sitting there in someone's house doing this when you know the person doesn't want it done, but they didn't have the proof saying, I don't want this done. So that's just kind of a real life.
So I'm going to share a testimonial.
Thank you, John. Wow.
If I may, with regard to my own family and my mother. She had all of her documents, power of attorney, DNR, and I was the person. She went into the hospital. My sister said, Mom's going in the hospital. They want to do a cath on her heart to see how good the vessels are and if she's getting good circulation through the heart. And I said, I can't be there. I've got appointments. You're good. They have all of the documents. She said, yes, they have all the documents. My mother coded while in doing the procedure, and they did not acknowledge the DNR. I wish I had known Richard at that time, or seen Richard at that time. I would have called him. But we had a very, very long stint with Mom, about probably a couple of months. Wow. And the doc kept telling my family members, she's going to get better, she's going to get better, she's going to walk out of here. And I said, we had a DNR 3 weeks ago, and Mom should be in heaven right now, because that's what Mother wanted. My question is there legal action against a health facility if they do not order the DNR? If they do not acknowledge the DNR?
You can sue anybody for anything you want to sue them for. Whether you win or not.
2024, he's not wrong.
Whether you win or not, I understand.
Yeah.
But you can sue anyone.
You can sue
Right,
any-
you could
you got a filing
moved
fee, you
her.
can sue anybody.
One of my doctors gave my mom some really good advice when my dad was probably going to be dying soon. He said, yes, have the DNR, but the doctor's own family, even though they were in the house with the DNR, for his mom, the EMTs would not acknowledge it. He told my mom, if you don't want to have that issue, just wait and don't call. Because there is a chance that they will not acknowledge.
True.
And we have a member of our family who's an ER doc. And quite a few years ago, he's been practicing a long time now, but he said, well, I've by law been forced to resuscitate at least 200 people. Only 2 of those people had any meaningful life afterward.
Wow.
After a certain age.
Yeah, it's sad.
So that was very helpful to us.
Okay, so this is, I'm not joking when I say this, but, so is there, I mean, because, I've had to call 911 before, just once. And luckily I was able to talk to them, but if I had DNR tattooed on my wrist, I'm really serious,
Yeah.
because how else would anybody know?
Yeah.
Except that if they open my front door, that tape thing on my door goes behind it and they don't see it. I don't want to tape it on the front of the door. But, would they honor my DNR request even though it's not?
You're dealing with humans,
Yeah.
and one might and one might not.
DNRB could stand for Donald Raymer or something.
I had a client that had the old form on the medical power of attorney, which is the medical power of attorney, and so we represented quite a number of doctors. So I asked these 2 doctors, and I said, if somebody gave you a medical power of attorney on the old form, would you accept it? And one of them said, no, it's on the wrong form. And the other one said, yeah, I'd probably accept it.
Wow.
So which doctor are you going to get? That's the problem. So best thing to do is just make sure you got the current forms and make sure everything's up to date.
Question.
Yeah, question and then a couple of comments. So both my wife and I have separate wills. I'm wondering if that's something that you recommend. They certainly do need to be updated, but we do at least have them. I think some of this is very valuable it because my parents, my dad had everything put into a trust. Everything was, except for things that, you know, ancillary things he just couldn't control. For the most part, all of it was taken care of, and the reason even why it was so beneficial for my sister and I was because my mom developed dementia, and everything was put in place before that ever happened.
Awesome.
And so the trust was able to be executed without her necessarily being involved. Plus, my sister and I worked together very closely and very amicably to get it all settled. You know that. Secondly, of the power of attorney, medical power of attorney and stuff, I don't know that, it's been 10, 11, almost 11 years now, I don't remember, but I had a massive heart attack. I was on a vent for 5 days, you know, and luckily that all turned out, thank the Lord, turned out well. But after after that, we had a will made, and every time that I go into the hospital now, they'll ask if there's a power of attorney, or medical power of attorney, you know, and we can tell them yes, there is. You know, they've never asked for it, although the financial planners have those documents like you have recommended. So sorry I'm taking so long. But
No. Great
Thank
for
you for your
sharing. Thank you for
testimonial.
sharing. Yeah, thank you for
Yeah,
sharing.
yeah, but we'll answer your question now.
To answer your question, I would never do a will jointly with a spouse. And the reason is because, well, I'll give you an example. The reason is because you may change your mind. The second spouse who dies, if you don't die together, could want to change their executors or their beneficiaries. And if it's all in a joint will, it just becomes very complicated to probate. I had a lady who, her husband died of cancer. They were leaving all the property when both were gone to the husband's child. But when her dad died, she caused just a lot of grief to her stepmom, just unnecessarily so. And so once we probated her husband's will, she immediately changed her will to cut out the stepdaughter. And so, not that that's an extreme example, but if it's all in one will, it's just very hard to probate. If there are any changes that need to be made after one spouse's death. You want to add to that?
No, it's fine.
Okay.
Let's stay with wills and trust for a moment. I have a question to ask the panel, and then I do want to give Marcie some time to specifically speak to her work with regard to elder law and Medicaid and the tremendous benefits that the VA, the Veterans Affairs Administration, has for those who have served. So to this point, we've been talking about will-based plans and trust-based plans, but I think it's important to get educated on executors and trustees. So if we could stay with the will for a moment and potentially ask the question, what makes a good executor? And then and the answer is probably the same, what makes a good trustee, and maybe the differences in the roles of each one. So maybe define what an executor would be with respect to a will and the qualities we would look for when creating our own plan.
The executor is the person that's appointed by a judge to gather all the assets, pay off all the legitimate debts, and administer the estate and get the assets to where they're supposed to go to the beneficiaries. Same thing's true with the trustee. Trustee gathers all the assets of a trust, pays all the legitimate debts and taxes, and passes the assets to where they're supposed to go. People think that they want to pick the child that they love the most to be in that position because they love them the most, and they need to understand it is not an honor, it's an obligation.
Absolutely.
It's a major obligation because if the bills aren't paid correctly, if the taxes aren't paid, Guess who's personally liable for those debts and taxes? Personally liable.
Beneficiary.
Yes. The trustee or the executor. So it's not an honor. So you don't pick the person that you love the most. You pick the one who can do the best job. So you pick the one who's able to follow directions and who's going to be able to get along with the beneficiaries, because you don't want a tyrant saying, I got all the money and I'm going to do it my way. You got to follow the terms. And we've had people that are appointed trustees of trusts who say, Mom never wanted to do it this way. I'm not going to do it that way. Well, the Texas Trust Code says if you have a trust, you follow the terms of the trust. Whether you like the terms or not, you follow the terms of the trust. And if it says to do this, you do that. You don't take it upon yourself to do something else. A common example of that is we do a lot of asset protection in our trust. So when somebody dies, when husband and wife dies, we pass it to the children in such a way that it stays in trust for those children. Now, a lot of times they get to manage it themselves, okay, but it stays in trust for them. And if it's in trust for them, their creditors can't take it away from them.
Right.
If they have a car wreck and it's their fault, the creditor can't get the assets. If they file for divorce, the ex-spouse can't count those assets. Bankruptcy court's not going to take it away from them. So they're going to actually get to keep the assets. But we've had clients who say, the children of clients say, we're not going to fool with that trust. We're not going to set it up. And so we're just going to give it outright to the beneficiaries. So if they do that, give it outright, because they didn't want to fool with the administration of it, and then later on that child gets sued and loses their inheritance, guess what that child's going to do to Sister Sally, who didn't want to do the administration? Sally, now didn't that trust call for you to put this in trust for us so we wouldn't lose it, and you didn't do that? I think you're responsible for these debts. So that's important.
If I may, this applies to my family with respect to the medical power of attorney and the durable power of attorney. In my personal situation, my wife is a nurse. So for the same family member, I may be the financial power of attorney, being in finance, and she may be the medical power of attorney for that family member. And I imagine that's maybe common to have different power of attorneys to help clients.
Yeah.
Yep. Mm-hmm. Based on capabilities, experience, trust, and things like that.
And you got 3 kids. You love them all. Okay. One of them's a financial planner. The other one's a doctor, and the other one he just can't seem to get a job. He can't rub 2 nickels together. But I love them all. Well, you never pick the third one as any trustee. I mean, you may love them, but you don't pick them as a responsible person. You just don't.
But we have seen that happen.
Yeah.
And
I love them all equal. I'm going to treat them all equal. Well, that's not the way to do it.
Thank you for that. Okay. I want to let Marcie shine a little bit, because to this point we've been talking in general terms about the importance of estate planning. But her work, especially on the VA side, is kind of resonates with me. While my parents live in Louisiana, they haven't had the pleasure of meeting the Johnson firm. But my dad is a veteran, and he served in Vietnam for about 2.5 years and was discharged honorably after 3. But his VA pension has saved his life. Mm-hmm. Literally. His VA pension has saved his life. And to this day, those veterans' benefits are providing for retirement income, adult daycare, respite care, and caregiver for my mom.
That's wonderful.
My father is bringing an income in from the Veterans Administration of $6,000 because he served. And so my point is, the work that you do on the VA side is incredibly important. Our only regret was not finding the VA sooner. Mm-hmm. My dad served in his 20s. He did not discover the VA benefits until he was around the time of his heart attack, late 50s. Mm-hmm. And so that's the only regret, but it has saved their life. So if you would, go into a little bit of detail and maybe some case studies on what you're doing with the veterans.
Sure. We have any veterans in here?
Show of hands.
Oh,
1, 2, 3, 4.
Do you know any veterans?
We all do.
Well, first of all, thank you for your service, We really appreciate what you've done for us. And there's this program that is not really advertised.
True.
And what's frustrating to me is I talk about it and no one knows about it. And so what it is, it's called the VA pension. Now, has anyone heard of the VA pension? Okay, good, great. So it's for veterans who were age 65 and older and that served during a period of war. They didn't have to see combat, but they were during the Vietnam era, Korean era. We don't really have that many World War II veterans
Not anymore.
still there.
Yeah.
Surviving spouses of that. I did a VA application for a surviving spouse of a World War II veteran just recently, but mostly we're talking about Korea and Vietnam now. But the VA has this program that they don't want veterans that served active duty during wartime to become impoverished paying for their long-term care costs. So they created this benefit that they don't advertise, but if you meet the qualifications, if you're married, a married veteran, right now this year you can get $2,700 a month tax-free for the rest of your life, which is, I can't do the math, but it's a lot.
Over 30,000.
Yeah, over $30,000. If you're a surviving spouse of a veteran who meets his qualifications, it's about $15,000 a month. But it's just a game changer. You don't have to be career military. You just had to have served 90 days active duty. 1 day was just during a period of war and honorably discharged. So there's some asset requirements and some income requirements, but your house is exempt. So that doesn't count against you. Your car is exempt. But real life examples is if you know someone who, let's say, a common example is you have a daughter whose mom is living with her or close by. Maybe she's got a few health concerns. So daughter is checking in. Mom moved closer to daughter so that daughter could keep an eye on her. And mom's husband served during wartime. Well, we can create an agreement with daughter and mom for daughter to get paid for what daughter's already doing. She's making sure that mom gets to the doctor on time. She's making sure mom's not a fall risk, that she's making her medical appointments, that she's shopping, that she's eating okay. She's doing everything that she's already doing, but daughter doesn't have a legal obligation to take care of mom. She may have a moral obligation, but she doesn't have a legal obligation. So we can pay daughter for care, oversight. And then by showing that we have now these medical expenses that are more than what mom is bringing in Social Security in her income, we submit that information to the VA, and VA says, okay, you meet the requirements to get what's called aid in attendance, is another name for this program. That's what's known colloquially. And so we're going to give you a check for $1,400 a month for the rest of your life. And it's been a game changer because it allows extra money coming in because money is tight. If daughter needs to have a caregiver come in, she now has the funds to actually have someone come in, and you can have parents stay at home longer because of this benefit, and it's just been a lifesaver. And especially for these families, almost every single one of them said, I didn't even know this existed. And now they're getting money to make a real difference in their families' lives. So that's where my passion is, because I can see a huge benefit and just a quality of life change on something that veteran was completely eligible for, but just didn't know about. And they deserve it. They served us. They protected us, and we need to honor them. And so this is a benefit.
We did that for my mother-in-law. her husband spent some time in foxholes in France in World War II, and he passed away. And so my wife was taking my mother-in-law to the doctor, and she'd go there check on her, and she did all these things. And so we executed what's called a caregiver agreement. And my mother-in-law actually paid my wife some of money every month. You got to do it every month. But we took that money and we put it in a bank account. We never touched it. Okay, if she ever needed something, we had funds to pay for whatever she needed. We couldn't give it to her, but we could use it for her benefit. And so because of that, she qualified for the pension and was able to have a substantial amount of extra money that her husband deserved. He earned it. It's not something we're taking. He actually earned that, spending that time in the foxhole in France. So it's a benefit. We've had clients come into our office and literally start crying when they get that benefit. It's amazing.
Another benefit that I know about, my cousin just recently received it. He served in Vietnam, and then he got prostate cancer. Prostate cancer. And they determined it was probably from Agent Orange. So he knows, he's spreading the word, but he knows a lot of veterans that don't know about this. He got a $300,000 and some odd settlement, and then he collects $3,500 a month or $3,300 a month for the rest of his life. But that's a little known benefit too.
Yeah, so that's called
that veterans are able to.
That just thank you for bringing that up. So that's called compensation. So if you were, there's a whole list of illnesses that the VA has related back and said, because they're a subset from Agent Orange. And so you can get, there aren't asset and income requirements to get the disability it's not pension, the disability payment. However, it can be harder to get because the process can take years to get, because you have to show the medical records in order to relate the illness back to your time in service. But no, it's an excellent benefit as well. The difference is that your illness for pension doesn't have to have any correlation with your time in service. And you didn't even have to see combat. Just a war was going on. I have a client that played in a band in San Diego, and he was eligible for the pension. But I think, did we bring those books on that, on VA?
I think so.
Yes, they're in the back.
Yes.
Okay.
Please grab a brochure on your way out.
But also, if you talk to, in conversation, if it ever comes up, if someone is getting compensation because they were injured during their time in service, ask them what their rating is. Because every veteran who is on compensation, they know their rating. But if they're getting, I would say, 40% or less, they ought to look at the pension, because you can get more under the pension program. You can't get both programs, but you can get the higher of the two. And usually, if you're 40% disabled or less, a lot of people have hearing loss because of, they were in our artillery. We can switch them from compensation to pension to where they may be getting $800 or $900 a month from the VA. Now we can switch to pension and they can get $2,700 a month. And so each situation is different, but you can look at it and determine. But you don't just have to be a veteran in order to benefit from these services. For non-veterans, I know that Ryan and Randy are big proponents of long-term care insurance. And if you haven't talked to them about that, unfortunately, we're talking about all these things about what happens when we pass away, but I don't know what the statistic is, but like 75% of us are going to become incapacitated at some point before we pass away. And the question is, well, how are we going to pay for that? And there's 3 ways you can pay for it. if you're lucky enough to have family members who will chip in and pay for it for you, that's wonderful. But most of us don't have family members like that. You know, you can pay for it yourself, but how far is that going to go? You know, I know over here at Christian Care Center, you know, assisted living is going to cost you $5,000 a month. Skilled nursing is going to be about $6,000 a month. That's $72,000 a year. You're in there for a couple years. I mean, think about your nest egg, how much you've spent your whole life to protect. Now, I'm sure Ryan and Randy have done if they're clients of yours, they've done a great job of increasing that. But yet still, I mean, $300,000 can be gone like that. And so what can we do? So a lot of times what clients that come to me, you know, they're looking at, well, what do we do? Well, I refer them to people like Randy and Ryan to look at long-term care insurance. And that's a great benefit. But it can be expensive. Those premiums can be high. And the best time to buy insurance was always yesterday. So, you know, if you can't afford the premiums, or your health is such that you're not health eligible to be rated, then what are your other options? Well, it's not the end of the road, because there are some things that we can do. I do for Medicaid planning this trust. It's a special type of trust. It's a trust above and beyond the types of trusts we've been talking about here. But what we can do is we can take assets that you're scared that you don't want to ever lose, and you can move them to be managed by your family. So if worst case scenario ever happens and you have a catastrophic illness or fall and you end up in skilled nursing, we could then apply for Medicaid, and Medicaid picks up the bill, and your assets that you work so hard to earn and keep can stay for the family. And the reason why that is because, so just a myth, you were talking about myths earlier, a big myth of Medicaid is that you get substandard care, and it's not true. There are Medicaid facilities that just deal with Medicaid, and they're probably not your first choice of places you want to be. But there are a lot of nursing homes that are private pay, but have a limited number of Medicaid beds. And it's just a billing issue. So you can have two people in a room. One is paying $6,000 a month. The other one is on Medicaid, only paying their Social Security a month. And they're both getting the same care from the same nurse. But what we can do, Medicaid looks back 5 years. So when you apply for Medicaid, if you do, they have in their rule book said, look, we're going to look back 5 years and see if you've made any gifts to get rid of your assets, because we don't want you giving away stuff to get qualified for our program. And we're like, okay, that's fine. So what we do is we plan outside 5 years. So I'll give you an example. I have a lady that she owned a commercial real estate, it's like a gas station or something, over in Burleson. It was worth over $1 million, and she wanted that to stay in the family. She had she had a little cash, she had some IRAs, and then she had this big property, and that was their pride and joy. They wanted to make sure it went to their boys. So what we did is we took that commercial real estate and we moved it to this trust. She put her boys in charge of it, they managed it. And then we waited 5 years. She lived off of the cash and she lived off of her IRAs. Her health was declining, but 5 years passed. And then she needed skilled nursing. So we applied for Medicaid, and on the application they say, have you given any gifts away within 5 years? No, we hadn't. It was more than 5 years ago. And so we only listed the assets that she had at that time, because that gift was outside their look-back period. So she was able to get on Medicaid, and that $1 million property was preserved to go to her boys when she died. And so there's planning that you can do if you plan early enough. Now, I will tell you that most of these people that do this type of planning, you got to be willing to give it some control. There's some, you know, the benefit is you're protecting these assets for long-term care later down the road. The downside is, if there is a downside, is that you're giving up control of that asset, but you're putting people in charge that you love and that you know that are going to act in your best interest. So yeah, you've got to be at that point. So most of the people that are doing this planning, unless you have a cancer or catastrophic illness, they're probably in their late 70s, early 80s when you're ready to not worry about that anymore. But that's just types of planning that you can do to preserve a whole lot of assets and still get qualified for programs and not lose all your assets.
So that's called pre-planning. There's also crisis planning. When we got to go in a nursing home now, do we lose all of our assets? How do we handle that?
Who's in favor of pre-planning over crisis
Right,
planning?
right. So I'll answer your question so crisis planning is emergency room planning. And a lot of people think, no, I got to spin down. I just got to spin down to nothing. And that's not necessarily true either. If you're married and your spouse is going into to nursing home, you have a lot more options. And a lot of times we don't have to spin down at all. And I don't want to get in the weeds too much, but so a spouse that's not in the nursing home can have unlimited income. So a lot of times what we do is we take whatever's over the asset limit, we just turn it into an income stream. We didn't have to spend down because the spouse can have unlimited income. So we just changed the character of the property and now they're qualified. And so you wouldn't know that unless you went to an expert, a qualified professional that does Medicaid regularly. And so if you're in that situation or if you know someone in that situation, don't think you know the rules. Don't Google it and say, this is what I gotta do. Talk to somebody because there are so many things that you can do. And going broke to get qualified is not the best way to do it.
Right.
Yes, sir.
Quick question back to what you were saying about VA benefits earlier. So for long-term spousal care, is that something like if neither one of my parents need that, but my dad's a veteran, they can go ahead and start applying for that? So date that it was needed, it's already approved. You don't have to wait however long it might take and so forth.
So you have to show, you can't pre-approve it. But so here's another example of looking at Google and disqualifying yourself. So to get aid in attendance, you have to show that you need help with 2 activities of daily living, which that's a coined term if you don't know what that means, but it's in the medical field, it's dressing yourself, bathing yourself, eating hand to mouth yourself, getting up from a seated position, walking across the room, toileting. But what people don't realize is that if your dad, is this your dad? Stepdad? If he's a fall risk, if he gets dizzy, if he's on blood pressure medication, there's a lot of things that we can do to show that he needs oversight. So if he holds on to a handle in the shower for stability, he needs help with bathing. Now, you wouldn't think that just by looking at the rules, but you've got to think outside the box. So, if he holds on to the chairs to stable himself to get up, that's help with standing or sitting. So I've got to get a doctor to fill out this form. It's you get it when it's the same thing as getting a checkup. I mean, so it's a short form. But I just have to have a doctor substantiate that, yes, he's a fall risk. And usually, I have clients all the time who come to me and say, I'll never qualify. I say, let me just ask you some questions. Do you have to hold on to a buggy when you go to Walmart just for stability? That's help with standing and walking. And so there are a lot of people who would be eligible that aren't eligible because they discount themselves. And so I would say, if we ask the right questions, a lot of times we can find those activities of daily living that they would otherwise not.
Let's talk about the 3-year look back at the VA trust.
Yes. But I will tell you one thing. Thank you, Richard. So same with Medicaid. So if he's not eligible for VA now, because he doesn't meet the health requirements, there's asset and income requirements for the VA as well. If he has more than what's allowed by program rules, you can go ahead and set up this trust and move those assets and then we wait 3 years, because there's a 3-year for that, then at that point, he would be financially qualified. We just, as soon as he was health qualified, then we could get the benefit. Thank you. Thank you.
One more question, and we'll begin the conclusion of our presentation. Go ahead, Roger.
Yeah, it's just a comment, and I know we're over time,
Yeah,
so
yeah.
I'll try and
Take your time.
cut it short, but
Yeah.
I do think when we talk about some of these kinds of things, it brings to bear the fact that we're not going to live forever. And that sometimes it's really difficult for us, even as evangelical Christians, and we know that we're going to spend eternity with the Lord. Sometimes it still is very emotionally hard for us to leave this life. And right now my sister is going through my parents' things.
Mm-hmm.
They've been dead for 3 years. You know, and so if you can prepare beforehand, it makes it much easier on your children when you're going. And I think sometimes it takes an emotional preparation for yourself for death too.
Mm-hmm.
Thank you.
That's a great point. Any more questions?
Behind you.
In the beginning, you were talking about the trust, and then you talked about a different trust to qualify for some of these programs. What is the name or the differentiation between those two types of trust?
So a living trust is what we've all been talking about, which just avoids probate, gets the assets to your family members. It can provide asset protection for your kids. That's a living trust. That's a changeable trust. The trust that we're talking about to get qualified for Medicaid or VA, it's an irrevocable trust. It can't be changed. So, and the reason why it's irrevocable is because we're moving the assets out of your estate, and then we're letting time go by so that we can legitimately tell these governmental programs, I don't have those assets anymore. Because you don't. You've gifted them away.
You gifted the assets
now,
away. Yeah.
You can gift them to the kids outright. You don't have to set up these trusts. However, if anything bad happens, they have a car wreck, go through a divorce, that money that's earmarked for mom and dad, they could lose.
Yeah.
So that's why I would never gift assets and say, kids, hold on to this, if I ever need it.
Good point.
Because you just never know what's going to happen. So we.
Am I correct, you can't be the trustee for the irrevocable trust?
The parent who's creating the trust cannot be the trustee. They cannot manage it. So that's why if you've got the right family, you can bend your child's ear and say, look, I want you to reinvest this way. So you can manage it, just not legally with the financial institution, but you tell your child, move this money
This
now.
is what we're going to do.
Right.
This is what we're going to do.
Right. Yeah. And right. But the good thing about that trust is, so it also acts like a living trust in that it avoids probate. So you're moving these assets, it acts as an estate plan. It's just, it's getting you qualified or positioned should the worst happen. We hope for the best, but prepare for the worst, and usually we turn out okay.
Thank you very much, everyone. In conclusion, I thought we would I'll make a mention of this. If any of you guys have a question that's maybe a little bit more private, I don't think our team would mind staying around just a few minutes if you wanted to ask something, a question in private. So we'll be around. But I thought what we would do in conclusion is just some closing thoughts from each of you about anything that what we've been talking about, and then I'll have some closing announcements and we'll conclude our presentation. So kind of putting them on the spot here, but any closing thoughts about how to maybe make the most of this meeting?
Just don't put things off. I mean, it's there's so many reasons not to do a plan. The one reason to do it is because you don't know what the future holds.
That's true.
And I mean, even prepaid burial. I mean, that sounds gross, but if you've ever had to go through a funeral with somebody that pre-planned, it makes it so much easier. So much easier. And if you've gone through a funeral without pre-planning, you know that it's a mess sometimes. So just just take care of it the way you can.
Go ahead, Marcie.
Oh, I was just saying, no one's going to love your family more than you do.
Yeah.
So, just have instructions. This is all this is. It's just instructions.
That fits with our theme of keeping it simple. Thank you for that. Leave them instructions.
Mm-hmm.
Leave them
That's
instructions.
what this is.
Thank you.
So one of the things that we see in our practice is when we visit with clients and prospects, we ask them a question: what are the two things in life that you worry about? And the first one is, I have assets, I don't want to lose them. The second one is, if I'm not able to take care of myself, I want provisions for that care in the form of long-term care or whatever. It's amazing. That's the two questions. That's really, they don't care about how much will my money make, how much insurance do I have a will, they don't ask all that stuff. Those are the two things. So I urge you to call us, ask us questions, come see us. We don't charge for consulting. If you come to visit with us, we'll sit down, we'll talk about where you are, what's going on, and then if you decide you want to go the step further, then we start taking a deeper dive into what you have and what you're doing. Thank you for coming. Thank you, Ryan, for hosting this.
Yep.
And
I've got some closing announcements to make.
yes, make your
Okay.
closing announcement.
So, show of hands. Are meetings like this beneficial? This is what I was hoping to hear.
Thank you.
We've kind of concluded the presentation with kind of a transition, by accident, into long-term care. This is an announcement to save the date for Saturday, April 13th. We'll be talking about long-term care and the government's plan for you and how you can avoid it. And then finally, a quote just to close things out. Don't let your learning lead to knowledge today. Please let your knowledge lead to action. Okay? Make a call. I don't think, frankly, we really care who you call. We're capable. We're available. If you have trusted advisors, please contact them and make plans. On behalf of the Johnson firm and Randy and myself, thank you for taking time out of your day.